Welcome to COVID Boomers and Karen's Oh My. Today we are going to be talking about trademark issues that come up when people try to register pop culture catchphrases and words. This is the first in a series of webinars that we are going to be presenting on intellectual property issues. Please feel free to submit your questions, which we will be answering at the end of the webinar. So the idea for this particular webinar came about because Justin and I talk a lot about trends that we see in the trademark office. To give you a little bit of background about us, Justin is a trademark prosecutor and I am a trademark litigator. Basically, what that means is he files trademarks and I fight over them. So let's start with the basics. What is a trademark? A trademark is a brand or source identifier. It tells the consuming public that you are the sole source of your goods or services. A typical trademark is a brand name or a slogan. So for example, Nike is a brand name, Just Do It is their slogan, and sometimes logos can also function as trademarks, such as the Nike swoosh. And one of the main purposes of trademark law is to protect consumers. So we want to protect consumers about the source of their goods. To protect them from confusion about the source of their goods. In other words, we don't want them to buy, say, Reebok when they actually think that they're buying Nike.
So leads us to some interesting discussions. One of the main things we wanted to talk about is this concept that we run into a lot where people think that if they just file a trademark registration or an application for one, that they'll own that word, that they'll own that phrase. And we get this a lot where people just think that they can prevent anybody from using anything as long as they file for it first and pay the few $100s to the trademark office. So an interesting phenomenon happens when whenever a new catchphrase comes out or a new pop culture meme, and people begin to file trademarks on these. And we find it fascinating because it's, I consider them to be contributions to the trademark office's operating budget. A lot of these don't go anywhere, but the two things we wanted to talk about today are descriptiveness and the idea is that if your word that you're using actually describes your product or service, then it doesn't function as a trademark. But then with that, there's this concept that some words are descriptive in some contexts, but not in others. So an example would be if I had an orchard and was selling apples, apple is a terrible trademark for what I do because it describes exactly what I'm selling. On the other hand, if I had founded a computer company and decided to call it Apple, that's different because nobody uses an apple for that phrase. So
you could even have a music company that you call Apple Records, and then you could file a lawsuit against Apple Computers for using that trademark.
So, and then you start getting all kinds of weird where, the phrase means something else and people spend lots of money fighting over these words. The second rule that we want to talk about is this concept where something is a common phrase, where if it's just something that people say, then it doesn't function as a trademark. And hopefully as we go through these examples, you'll see. The first example that we had was this phrase that's come out in the last, 6 months called "Okay Boomer." And I'm just going to give you a short definition in case there's anybody on here that is not familiar with that, but it's a catchphrase that's used by teenagers or young adults to dismiss or mock outdated attitudes typically associated with baby boomers. So just to get us started there.
So, Justin, can you give an example of how someone would use "Okay Boomer"?
Oh, ouch. So a typical way would be if, for example, it would just be a teenager or anyone who's not a baby boomer, basically using it to dismiss somebody's idea. So if somebody, an older person like a baby boomer, were to say something that seemed out of date, the way to dismiss it would be with this phrase, and it's not a particularly polite phrase. So what's interesting is we looked up, and as of a couple of days ago, there were 12 different trademark applications that have been filed for "Okay Boomer," just for this phrase. And 4 of them, just to give you a breakdown, 4 of them are for clothing. 4 of them are toys and games. And then there are a few others for just random things. And then one is Fox Media actually filed one for a reality television show.
Wonder
And
what that's about.
who knows? It's probably about etiquette. So they have the ones for clothing. What's interesting about it is, and here's how you figure this out, is if you run into somebody and they have a t-shirt that says OK Boomer on it, are you going to think, oh, that must be the OK Boomer company, right? That made that t-shirt? Or is it just like, oh, that's a funny thing to have on a t-shirt? Or is that a mean thing to have on a t-shirt? And that's kind of where you start to see this little trademark distinction. Now, what's interesting is that these trademarks are starting to be refused. So Fox Media, their trademark got refused initially because it's a common term. It's not, people don't see that and think, oh yeah, this is going to be a source identifier. Now Fox Media, if they spend enough money, they'll probably get a trademark out of that eventually. But these clothing ones, the OK Boomer for clothing, I think that, a lot of those will be donations to the trademark office. Like nobody's going to think that that's an actual company. And I don't know that the trademark office is going to let them get it.
Yeah, I agree with that. And now, moving into the next pop culture word, Karen. And no, I'm not talking about this because my name is Sharon. I don't particularly like this term. It's a pejorative term that's used in the United States, and it's intended to describe a white woman who's seen as entitled, usually middle-aged, and the stereotype is a woman who's asking for the manager to complain about something she shouldn't be complaining about, or refusing to wear her COVID mask. I think everyone gets the basic idea. So, and there's a lot of memes going around on the internet about these so-called Karens. And what's interesting about these applications, and there have been approximately 9 filed so far this year, is that all but one of them were filed by men. So you can read into that what you will, but they've mostly been for clothing. Again, displaying on the front of a shirt, "Don't be a Karen," "Not today, Karen." I don't even know what this one means. "I wish a Karen would."
So doesn't that kind of illustrate the point that if you have that on a t-shirt, "Don't be a Karen," people don't naturally think, oh, Gap must have changed its name, right?
Exactly.
Like,
they don't think
it's just
"Don't be a Karen" brand. They think, oh, haha, that's funny. Or they think, oh, that's offensive. They don't identify it with a source of goods. And so even though these haven't been decided yet by the trademark office, I think it's a pretty good bet that they're going to be refused. An interesting one, and so one point that I think you made earlier, Justin, is that these people who are jumping on the bandwagon to register these trademarks, they think they can monetize it by filing trademarks, and they think they can exclude others from using those popular catchphrases or words, and they can't do that. That's the whole point. So there is another interesting one, and it'll be we'll have to track to see what happens. There's an application for Karen from next door as a beer, and you can see that we put on the screen the specimen that was submitted to the trademark office for this application. It has sort of that obnoxious picture of a woman, and it says Karen from next door. It's not clear to me whether this is really intended to be the brand name of the company, or if it's just, the beer. Again, similar to the way t-shirts display an ornamental version of the design. And I think that what's going on here, Justin, is a lot of people are confusing trademark with copyright. We've talked a lot about this particular issue. I think in the general public, there's a misunderstanding about when you can get a copyright and when you can get a trademark. Don't you agree with that?
I do, because the artwork would be copyright. Although looking at that picture again, I just realized I'm not sure if that may be a faked specimen of use anyway, because it looks like somebody just put a sticker around a beer can. Like, I was looking at it close, it doesn't really look like. So anyway, that's another issue for another one of our discussions someday. But yeah.
there are the thing about Karen that makes it a little bit different than OK Boomer is that there actually are people named Karen, and there are legitimate companies that have the word Karen in their name, whether the owner of the company is named Karen or not. And we found over 480 trademarks in the USPTO with the name Karen on it that aren't trying to capitalize on this, OK Karen sort of pop culture reference.
Right. Maybe the owner or some person who's doing a trademark for their name, which has its own set of issues that we can talk about, but those can function as legitimate trademarks. It's just in this context where I think they're going to have trouble. Where
So,
they're,
and in 10 years from now, is the OK Boomer clothing company really going to want to be called OK Boomer?
that's true.
Yeah.
That's true. So, and that brings us to the last one, which was interesting, is COVID. So, and I'll give you a short definition of COVID. Actually, I'm just kidding. If any of you don't know what that is, I do applaud you for somehow finding our webinar, but we'll just assume that everybody knows what COVID is by this point. So what's fascinating about COVID is that the phrase didn't really exist until February, once COVID-19 sort of was given that name. And the trademark office records, they actually track that. So before February 2020, there had only ever been one trademark application for the word COVID. And it was for some random company back a long time ago that had filed. And what they do is they make those little holographic images that go on credit cards, or used to. I don't know if they're still there or not, but and then the company went away. Since February 2020, there have been 335 trademark applications with the word COVID in it, and another 51 with the word coronavirus in it.
You wonder, why would someone want to call their company Coronavirus Inc.?
which again brings to bear the same question. Like, people are sitting at home thinking about this and they're like, oh, I should file a trademark application and, help support my local trademark office. And so I broke down some of these. Almost 120 of them are for apparel. So fully a third of these trademark applications, or more than a third of them, are for t-shirts. And which I find fascinating that, like, I don't know how many COVID t-shirts you own, but I
actually don't own any yet.
I think mine are all delayed, shipping delays and that sort of thing. So, but apparently people really thought that, that they could get trademarks for this word. And then I thought this was interesting too. Only 74 of them are healthcare related, right? Which is where you'd think that people would be putting COVID into their healthcare product, but more t-shirts than.
Doesn't that get into an interesting question about descriptive? So if you're actually selling COVID masks and you want to call your company, COVID masks or something, COVID protection services.
Right. And in that context, the trademark office also won't let you protect the word COVID. So now if your mark was COVID and it's for a healthcare product and that's it, they will just refuse you because it's descriptive of what you're doing. If it has another word in there, say it was, like you said, COVID mask, like that's probably not going to get through because you've got like two descriptive problems, right? Like
yep.
COVID and it's a mask. And that's what your products are. So they're just, you may not even be able to get that. Sometimes they'll let you move to what's called the supplemental registry, but.
And don't you think it's counterintuitive for people because they want a brand name that's going to describe their products or their services so that people will know exactly what they do, but they don't understand that for trademark purposes, you actually can't do that.
Right. And it's this fight that's constantly happening between the marketing team and the legal team, as to what they should call their things, right? And so the rest of them are for random things like bumper stickers, jewelry, all these sorts of things. And so to give you an example of a few of these, the very, very first one that was filed had the word coronavirus in it. And it was for the coronavirus survival guide. So, and I don't know if you've picked up a copy or not, but no.
No, I haven't, but I've been doing okay.
Right. But it's for a magazine about surviving coronavirus. And to give you an example, so it's Coronavirus Survival Guide, and it's for a magazine. And the USPTO said, no, I mean, you are preparing a magazine that is a survival guide for coronavirus. Like, no, you can't have that. You can't stop other people from using the phrases. So that's exactly what happens when you use these descriptiveness ones. And so, right there, $275 contributed to the trademark office. This one I think is interesting. The very, very, very first one for COVID was called COVID-19 Vax, and it was filed for vaccines. And this was clear back in February 11th, 2020. So that's pretty exciting, right? I mean,
yeah, it is exciting. Was it an intent to use, or were they claiming that they actually used it at that time?
This one was definitely intention to use, but the problem is I looked up the other trademarks that this company owns, and it's all beer and clothing.
Okay.
So
not too promising.
Yeah, not very promising. And that's going to be interesting how they show proof of use on that. But it is an interesting illustration where clearly someone thinks that if they file this trademark and they're the first ones, that somehow they're going to be able to, hold somebody up later and kind of get money out of it, right? When somebody wants to call their thing the COVID-19 vax or whatever. So
that's what it's really all about, isn't it? I mean, they're trying to be the first one to get it, so right, they can stop everyone else.
And the trademark office refused that one too, because it's descriptive. That one was kind of fraught with problems. And then I guess just one more, and we can take a bunch of questions. And also, yeah, if you do have questions, like go ahead and put them. We're going to go to the Q&A here in a minute. But this one, actually I have two more, sorry, because these ones there's so many of them. So then the next one is COVID-19 for t-shirts. And that one was also refused because it doesn't function as a trademark. Like if you write COVID, just like these other ones we've talked about, COVID-19 does not, like, written on the front of your t-shirt, nobody thinks, oh, that's the COVID-19 company.
Right. And to be clear, so when you're submitting your trademark application to the trademark office, you have to submit what's called a specimen of use, which shows how you're going to be selling the goods or services in commerce. And for clothing, the way that you show the trademark office is you don't submit a t-shirt saying on the front, I survived COVID or COVID-19 or whatever it is. You have to have the label, the hang tag or the label inside the shirt to show the brand name. That's the key.
Right.
So,
and there are a couple of ways to do it, but again, it's the source identifier. It's not the artwork. If they have artwork, go down the street to the copyright office and it's way cheaper. So, so then the last one that I thought was really interesting was really early on, a guy named Charles McDermott filed a whole bunch of trademarks for I survived COVID-19. And this would have been early March for all these. And he filed for, again, it's apparel, it's for charitable fundraising, like all these things that he filed for. And I think he contributed, I think it was maybe $2,000 worth of trademark applications, because the trademark office, they don't refund anything. So once you make your contribution, it's good. And, but what's interesting about this one, so he filed for all these things and then maybe a month later he abandoned them. So I don't know, take that way you will. Hopefully he did survive.
Either he got some very good trademark advice or
yeah. So, but just kind of interesting that there are that many trademarks and this happens. And, if we were to do the seminar in 6 months from now, well, they'd probably still be all COVID, but there would probably be some other pop culture things that'll pop up.
Yeah. And you can go to USPTO yourself if you want to. It's uspto.gov, and you search under the TESS function. It's the trademark electronic search function, and you can type in any name you want. It's sort of fun to do that, and you might not be surprised, but you might be surprised by what you find there. We searched for a whole bunch of different pop culture phrases and found all kinds of interesting ones, everything from May the Force be with you, not filed by Lucasfilms, to to these ones that we talked about today. So
Yeah.
just, it looks like we've got some questions.
Yeah. So real quick before we do those, sorry, was just wanted to kind of sum up real quick and then we'll go.
Oh, sure.
Again, purpose of trademark is identify a source or a product. You're not protecting the ornamental design. If everyone out there that is using that phrase, save your money. And if it's really just decoration for your product, or it actually is your product, the word is your product, then save your money. I mean, it looks like I calculated that there were more than $100,000 in trademark contributions from the marks that we just talked about today that are it's just money that people will not get back. So, and a few of them will get through, and we can talk about that another day about how you can get through some of these. So, let me go here. The first question we have is, can have people copyrighted Karen?
That's
Do you
an interesting question. Justin, do you want to take that one?
Sure. So that's actually a trick question. And the reason it's a trick question is that short phrases are not eligible for copyright. So the word Karen itself would not be. But if you were to take, and I forgot what that label was on the beer can, but that label with all the artwork, that becomes eligible for copyright because somebody spent some time. They spent more time on the design than they did thinking through their trademark strategy.
Right, and basically copyrights are creative works. And that's how you can really distinguish it in your mind. A trademark is a brand, or the image is intended to identify a brand, whereas copyright is a creative work. It can be anything from a photograph to an essay.
Right. So then the next question here is, this is an interesting question. Has the USPTO office been responding slower during the pandemic? That's an interesting question. So what was unique about the trademark office, and this applies to the patent office as well, is at least in the trademark office, a lot of those examiners have been remote for a long, long time. They have a program where they have to work at the USPTO, but it's so phenomenally expensive to live in Alexandria, Virginia, that once they complete a certain amount of time, then they move. So when I talk to trademark examiners, they'll be, I talked to one yesterday, she lived in Utah, Michigan, wherever. And it's the same with patent examiners. You just never know where they're going to be at. So their systems are the same. So in fact, I think that it's actually sped up a little bit, because I think that a lot of them, they get paid based on how many they complete. And since they're stuck at home, I actually think that they're running through these faster, which is really fascinating.
Well, so the next question is, why is there a misconception about what people can do with trademarks? That is, that they will somehow make money. Did someone somewhere along the way actually make money this way? And I think part of the reason there's a misconception is the confusion between trademark and copyright. I think what I have seen, and Justin, you can confirm this, is sometimes people actually are able to get marks through that they should not get through. So as an example, there was a phrase from the movie Home Alone, which was, Merry Christmas, you filthy animal. And there was a company that actually was able to register "You Filthy Animal" as and the specimen they submitted showed it on the front of the shirt. Now, normally that should be rejected as merely ornamental use, as opposed to identifying the source of the goods. So number one, occasionally I think they slip through depending on the examining attorney. And I think that, again, there is a misconception just in the public. There's a lot of confusion if you don't work in this space or you don't have a lot of experience with intellectual property. People often get confused between or among patents, trademarks, and copyrights. So sometimes people will just file these trademark applications and they'll try to stop other people from selling them. From selling marks that display their goods, and because people don't want to spend the money to fight about it, or they don't want to hire lawyers, they go along with it.
Yep. which actually brings you to the next question is how many of the filings were completed by attorneys? It seems like these would be vetted out if these people had consultation first. So that's a good question. I did not check how many were filed. I did notice that most of the apparel ones are filed by individuals, and most of the ones that are, so, and we didn't get into this, but a lot of these have other problems. It's not just a descriptiveness problem. Like they've really kind of messed up some of these applications. So, you know, let's call it a third, maybe half. And the difference is for those, like ones that are truly a catchphrase, like COVID-19, those kind of things, most of those are filed by the individual. But then there will be some where it's COVID and then they have some other word with it. And a lot of times those will be filed by attorneys, and they're going to deal with the issue of not, you know, they knew going into it, they couldn't protect COVID, but their marketing team still wanted that in there. And then they're going to go for the rest of the phrase with it, and they'll just have to disclaim that phrase. So, but then you also have, and I've had this where I have had marks where I will tell the client, like, can't, you know, we're not going to get on the principal registry. And there's an option. Sometimes you have an option to go to what's called the supplemental registry. And it's sort of like hanging out for a while. You can't stop anybody else from using it, but you get a few benefits. So sometimes people want to do that. So there you go. So hopefully that's it, answers that question. And then do you want to take the next one, or you want me to take the next one?
Sure. The next question is, LeBron James tried to trademark Taco Tuesday last year or earlier this year. It was denied by the trademark office. This is a person with a lot of resources and presumably an extensive legal team. Why would a lawyer try to get that through the USPTO knowing it is going to get rejected? That raises a lot of issues. And, you know, Taco Tuesday, I think that is probably a pop culture phrase. It is not, it does not identify a source of goods. I'm not aware of whether LeBron James has any Taco Tuesday products or services that he offers.
Was it, sorry, I'm trying to remember. I don't remember this case exactly, but I feel like this is, and so this I may be making this up, but if I am, it's really a good reason. But I thought this was actually to try, like, I thought somebody had come after him for using it and he filed it and got rejected, but that means that the other side doesn't have rights to it. So this one may be a lot more complicated than.
Yeah, that's an interesting one. We'll have to look at that. But generally speaking, lawyers, you know, sometimes lawyers try to push the envelope, right? They tell a client, you may be able to get it through, you may not. It depends on the examining attorney. We expect to get an office action, which is when you file the application. And after the initial examination, the examining attorney comes back and says, we either need you to clarify something, or we're issuing a preliminary refusal and we need you to give more information. So sometimes you can get through those preliminary denials. So attorneys don't necessarily file applications knowing they're not going to get through.
Yep. So I think we have time for maybe one more. We're at 12:30, but the next one, do you anticipate there will be litigation between any of the entities, parties who have attempted to register these marks, or will it not get that far?
I think for this one, probably not. I think that the litigation usually happens in this context when someone is successful in getting a mark, or they've put a lot of resources into it, because trademark litigation can be very expensive. So if they're just selling a few t-shirts and they're not really making a lot of money on it, it really wouldn't be worth it to litigate the issue. If, on the other hand, they've got an Amazon store and they're really booming, no pun intended here, then they may try to stop other people, maybe send a cease and desist letter, but I would doubt that any of these would get to litigation.
And then I'll just take this last one. There's one, I'll grab one of these because we're over time and we've got to end. But can you give a clarification about the difference between T's plus and T standard? That's just, T's Plus is cheaper. T Standard is more expensive. T Standard, you can write your own description, and T's Plus, you have to use one that the trademark office gives you. So, all right. Well, thank you all for attending. Hopefully enjoy this. Please, give us any feedback you have, and we'll hopefully see you next month.
Yes, and if you want to follow up with either Justin or me with any specific questions that you have, feel free to email either of us. We're happy to talk to you at any time. Thank you.
Thank you.